We'll now move to our final panel session. Again, it's on From Mandate to Impact, implementing the PIA's host community development framework across Nigeria's midstream petroleum value chain. Please put your hands together as I invite the moderator for this panel, Senior Associate at Templars, Munachiso Michael. And my panelists, Dr. Mustafa Lamordi, Executive Director, Health, Safety, Environment, and Community, NMDPRA. He's already on the call, and he'll join virtually. And then we also have the Group Head, Legal and Company Secretary, Oil Serve Limited, Humphrey Onyoku. A warm round of applause for him, please. And the final panelist is the secretary, the company secretary at Pipeline Infrastructure Nigeria Limited, Chimenerem Ikechi Eshiet. Please put your hands together. Please continue applauding till Chimenerem gets to the stage. Our final panelist is unavoidably absent, so we'll just have the same time. And then please remember that we have 10-15 minutes for questions. And let's also be very mindful because we still have the Q&A wrap-up, and then we break for lunch and close the event. So over to you, Mr. Moderator.
Thank you very much. Good afternoon, everyone, and welcome to our final session today. I hope it will be worth your wait and probably turn out to be the best of the lot. So I want to thank Dr. Lamode for the presentation. He has pretty much set the ball rolling and has made my work a lot easier, even giving us answers to some of our questions, which we will discuss in detail here. Now, we've talked about the PIA being 5 years old now. Now, for many, the PIA is different things. For some, it's a fiscal reform. For others, it's institutional restructuring, while for another few, which another law we will be discussing today, it's a community development framework. My panelists here will be discussing some of the key issues which have pretty much plagued the passage of the PIA and the provisions of Chapter 3 relating to the creation of a host community development fund. Joined here by my esteemed colleagues and panelists. And I'm going to start by asking one of the key questions that continues to arise. And this question, I would like to direct it to Dr. Lamode because he is the authority on ground. And the question is, does the host community development trust obligation apply to midstream operators? Now, I'll give you the reason for this question. If you look through Chapter 3 of the PIA, the Act continues to make reference to settlor. The obligations are that of the settlor. And the PIA, in defining a settlor, defines a settlor as a holder of a petroleum PPL or PML, which are upstream licenses. Now we have a host community development regulation passed by the authority, which has pretty much provided rules that will guide operators in the midstream sector. Now lawyers, being lawyers, we like to take things on face value. So Dr. Lamode, if you will oblige me, how do we tie or how do we really bring in this host community development trust obligation into the midstream petroleum sector? Does it really apply to midstream and downstream operators?
Thank you so much, moderator. This is a very, I think, difficult, important question that I think and that we need to start with, and it actually lays the foundation of whatever we're doing today. If we get this wrong, then the foundation is very, very weak, and anybody can come and challenge us. But let me just start by saying the premise itself needs correcting before the administrative law question can be answered. Midstream operators were never going to hold a PPPL or a PML. You only get that, in the upstream regime. So this instrument actually belongs to the upstream operation by statutory design. And so when you look at the HCDT regulation applied to a holder of a licensee, a license engaged in a midstream petroleum operation as prescribed in section 318 of the Act, and also our regulation 2 that follows. And regulation 44 also defines licensee and license independently of the PPL and the PML. So a license issued by authority specifically for midstream or downstream operations, the obligation is not an extension of the upstream instrument to operate to operators who lacks it. It is actually not a self-standing application of Chapter 3 of the instrument midstream operation. So regulations that were made, as I mentioned in my presentation, were actually taken from Section 33 of the PIA and Section 234 subsection 2 and Section 235 subsection 6A of the PIA. So if you look at Section 234 subsection 2, as I mentioned, it expressly empowers the commission and the authority here, as mentioned, as I'm now quoting the PIA, to make regulation, and it's based on this. Even based on this alone, the authority, went ahead, because this is the area of host community under Chapter 3 is under the authority's competence jurisdiction, to actually draft the midstream and downstream regulation on host community, which is distinct, from what you have with the commission. So it is a regulation that applies to all the provisions in an obligation that are subject to every licensee, within, that competence is squarely, within that. We're not borrowing anything from the upstream and machinery. It's just in operationalizing it. It's a parallel statutory mandate using the authorities on delegate power. So that actually sets the face. This is the regulation was drafted and gazetted based on the authorities' power to do that. So the authority has the power to gazette any regulation. And so an operator must, be most viably challenged. It's not a PPL or a PM-led obligation. That argument misread the regulatory architecture. The more defensible line will also be misread, be an argument that says Chapter 3 drafting and Section 240 subsection 2 that talks about the 3% formula, that actually excludes the authority, which is just conceived as an upstream thing only, stretches and delegated beyond what the intent of the National Assembly is in drafting this regulation. So what we actually did is to borrow on that as an extension, but the authority has the power to draft the regulation. So what we did was within the powers of the authority. I think I would like to stop there here. Yeah.
Thank you very much, Doctor. Thank you, and thank you for establishing a legal basis for why we are here. Now we understand why the NMDPRA has passed a regulation making provisions for host community development trust. I'm going to harp on what you said about the 3% contribution and then latch on to another dispute. In fact, I will ask this question to Chinemerem first, and then I will ask you, Doctor, to also give us what you take. Now, the question is the 3% contribution formula adequate? Now, why? If you notice, with regards to contributions in the sector, it's usually a percentage of your profit But this particular one says 3% contribution. Now it is 3% of the actual annual operating expenditure of the preceding financial year is what you are to contribute to the host community development fund. Now, players in the industry have said, especially the host communities have said, how do we even determine this 3% is not enough? Why don't you peg it to their profit so that it's easily determinable from their financial statements and the like? So, Chinemerem, I will ask you, should NNDPRA use these regulatory instruments to expand this contribution base, for example, by tying contributions to revenue or profit rather than operating expenditure? Or would such expansion require legislative amendments?
Okay. Thank you very much, Mr. Moderator, for that question. I'll start from the first one, which is whether the 3% is sufficient. And I would like to say that it depends on the context from which we look at it. And I would want to also imagine that the draftsman was trying to avoid a situation where you make the settlor or the operator the sole contributor to the trust fund. So what that means is for the trust fund, under section, I think 237, the trust can receive donations, from other people. So what that means is that the settlor or the operator is not the sole contributor. So if we look at it cumulatively, we would see that, yes, it is adequate. So you also want to limit their control, because if you have a situation where the settlor alone contributes more than 3% or so much more, they would of course want to have total control over the trust fund. So now imagine where there are also donations coming in from other people into that trust fund, and again the trust is tax exempt. Yeah. So you don't have to pay tax on whatever comes to the trust fund, making the money more available or sufficient for the host communities. So with that, I want to say that I believe it's sufficient for the host community. That is not the only source of income or funds. Again, if you look at section 239 of the PIA, it says that notwithstanding the provisions of the Act, nothing shall preclude the host communities from their entitlements under any other law. Yesterday, I remember a question was asked as to whether there's an overlap between yes, you asked that question, whether there's an overlap between the Local Content Act and this fund. So what the PIA clearly states is that this fund does not preclude the host community from their entitlements under any other law. So they all can coexist. There is no overlap, meaning that you have enough resources. The host communities have enough resources that could be used for their development. So that is that on sufficiency. Again, on whether the authority can increase the number. I don't think they can, because the PIA is very explicit. It says not only the rate, but the base for contribution, which is the operating expenditure. So for you to change that, you're touching on a core subject of the PIA, and that would need parliamentary approval. So it's not something that the authority can regulate on, because the purpose of the regulation is simply to guide the operators on the implementation of the PIA, not to change it or to amend it in any way. So if we're talking about increasing the percentage, this is an amendment, a fundamental amendment that would need parliamentary approval. Thank you.
Thank you very much. That's very robust. Dr. Lamode, I would like to get your thoughts on this. I know this is me putting you on the spot, but I would think that it would be important to get the authorities' voice on this. With regards to the 3% contribution, what really formed the decision for this particular amount? And does the authority consider that this is robust enough to satisfy the purpose for that Chapter 3 of the PIA, which relates to host community development fund?
Thank you, moderator. I think I would like to carry on from where my fellow panelist stopped. I think she actually did justice to that question. But just from the authorities' perspective, I would also like to reiterate that, amending that is will require legislative amendment. So it's not a regulatory action, and the reasoning is structural, not just policy reference. And if you look at Regulation 24, subsection 1, it sets the contribution at 3% of actual operating expenditure. And this is deliberately mirroring the metric that the National Assembly set for the upstream HCDT in section 240 subsection 2 of the Act. So NMDPRA, or the authority, did not invent the OPEX basis. It tracked a legislative choice already been part of the PIA. Regulation 24 subsection 9 does show that the authority exercises interpretive latitude within that metric. So excluding the capex, as I mentioned, any depreciation or amortization, but interpreting what counts as OPEX is qualitatively different from replacing OPEX with revenue or profit as a funding basis. So swapping the matrix entirely will not be interpretational, if you look at the PIA. It will basically substitute the intent of the PIA by the National Assembly, with the regulator's own choice. And our job as regulators is basically, to implement the regulations and provisions of the PIA, not to change it. Any changes would require that, parliamentary amendment. So the other part of the question is, should we look at other source of funding, like the revenue or profits-based formula rather than the OPEX, and this will basically change the economic structure of the whole thing. And of the obligation, and profit is volatile and very contestable in a way OPEX is not, and our revenue also ignore cost structure that entirely. So that is precisely the kind of substantive changes that exist, what regulation on areas within the competence. And under section 234 subsection 2 of the PIA, which permits that latitude. So it will very likely draw a successful, challenge if any attempt is made to change that without going through the parliament. So if host communities now, if you're coming from the angle of host community and they're looking for, it's not enough, or they want an increase, or they are advocating for a place for this action, I think the technicality, sound and politically available alternative, as I said, tightening the OPEX definition further. So the authority has that latitude, through the guidelines. And if you look at regulation 53 of the NPHCDT allows that. For instance, you can clarify treatment of intercompany charges or shared service allocation rather than contesting the OPEX basis itself, So our advice, to legal counsel, is to engage on the definition so that we get it precisely where the authority has that genuine latitude to resist, conflicting that with the base formula question, why it does not. Thank you.
Thank you very much, Doctor. Thank you. It's really comforting and encouraging the way you are churning out the provisions of the regulation. Shows that you've really immersed yourself in it. So I'm going to go, so Chinemerem, you said something about the PIA, the provisions for the Host Community Development Fund is like no other law can usurp this provision. But now there's a very keenly contested point within the Act, which is the sabotage for fixture clause. And Humphrey, I'm going to ask you a question on that. Now, this is very contested because what the Act says is that if vandalism, sabotage, or civil unrest attributable to a host community results in damage to petroleum facilities or disruption of production, that community may forfeit its Host Community Development Trust Fund entitlements, equivalent to the cost of repair or damage cost. Now, the problem here from a legal perspective is how do you come about a blanket punishment without fair hearing? There's a fair hearing issue in this. Now, there was a case that got to the Federal High Court where a civil society group challenged this same provision to say, we are going to punish us. How do you even determine the cost of the sabotage, who is responsible, and how do you even make it the responsibility of the community to suffer for this? Now, my question is, following that decision and, with regards to fair hearing, what's a practical obligation that General Counsel needs to take cognizance of in advising clients on documenting incidents with regards to this sabotage and, how the evidential burden will sway? What do you think that General Counsel needs to take cognizance of so that you are able to prove or disprove such sabotage?
Okay, yeah. Thank you for that question. And before I even address it, I would want to also thank the Commission, or the authority, for inviting us to this panel, particularly myself, my organization. I work with OISAF. We are one of the foremost EPC contractor in the country and also beyond. And sometimes when these conversations happen, we are left out in the room because meanwhile we have a critical stake because in the curve, in the service delivery curve. So to address your question first, before I will also pivot to a conversation that happened yesterday. What is paramount or key with this sabotage publicity clause is for us to understand that the underlying philosophy for the HCDT is about building a co-creation or This one? Okay. It's about building a co-responsibility relationship between the community and the operator. So it's important to bear in mind that that's the underlying philosophy driving the HCDT, right? Because the precursor with the GMOs and all of that started that journey. So the whole essence is to tie responsibility so that the community also have some level of ownership with activities in their locality. So placing that responsibility on them certainly is not, I wouldn't want to, for us to go technical about is there a room for fair hearing or not fair hearing, but it's for us to keep tab with the whole essence of this whole setup, because it's about building governance framework around that relationship. So from a practical standpoint, what is critical or key is setting a very strict governance framework around that setup in terms of making sure that the organization, the governance are properly set up of HCDT. And with that in place, it engenders the kind of relationship that needs to support such facilities not to be victims of this sort of sabotage issues. I think we have also seen the results if we follow some of those NNPC reports. When they issue report on instance of vandalism, they have also premised the fact that there has been a substantial decrease by virtue of the fact that some level of strategic relationship has been built between the organization or the operator and the community to have a co-responsibility over facilities within their domain. So from a practical standpoint, one, I don't consider I sort of appreciate the thinking of or the ruling of the judge in that matter by obviously dismissing that the way which he did, because this is also to save the whole essence of the HCDT, because if that fabric is removed, that could obviously impact on the success stories that we've listened to the State Director talk about the journey with the HCT. And to build on that, it's important that the philosophy that underlines it is sustained and kept by virtue of even the courts supporting that spirit, so that we don't lose those gains by trying to erode the level of trust and relationship this framework is set up to do. So what is key, from a practical standpoint, is about having a governance set up around that and have it properly organized and run in accordance with the fact that there is, basically processes to enable that relationship to exist, communications and correspondences. So even if there are grievances, that governance will also have a grievance resolution mechanism well institutionalized in the process to manage these issues. So with that whole philosophy that is driving the HCT is retained and sustained so that we can also gain the value and the benefit of what it's meant for.
Thank you very much. That's very clear. And you've talked a lot about governance, and it gives the picture that the responsibility is not just that of the operator or the settler, but also that of the community. And that takes me to my next question, because now we're looking at the PIA and how it's worded. And one of the first things that jump at you is the constitution of the board of the Host Community Development Trust. The Act says that the settler, which is the operator or the oil company, appoints members of the board. Yes, while they appoint them from the host community and the host community is represented. But my concern is the governance integrity and who in essence controls the trust. What legal mechanisms or regulatory safeguards can General Counsel build into trust constitutions to insulate, Chinemerem, I'll be asking you this question, to insulate the Host Community Development Trust governance from operator influence? There's a popular saying, he who pays the piper dictates the tune. So is the operator who is appointing the board of trustees, do they now call the shots? So what safeguards have to put in place to ensure that operator influence is kept under check while maintaining the settler, who is the operator's legitimate interest in accountability for fund deployment?
Thank you very much. That's an interesting question. So for me, looking at the PIA, again, I can see that it says that the constitution of the HCDT will allow the Host Communities Development Trust to manage and supervise the administration of the fund. However, managing is different from controlling. So you could be managing a business, a fund, but you may not have total control over it. Again, the settler gets to appoint the members of the Board of Trustees for the fund. So just like you said, whoever plays the piper dictates the tune. So if I'm going to appoint members of a board, it would just mean that I would have certain level of control over that board. If you look at the PIA again, it is littered with a plethora of control measures or powers given to the settler. For instance, the settler can determine the number of the Board of Trustees, can reduce their frequency of meetings, can decide not to fund the reserve fund. So all of these are control, right? Whichever way we want to look at it, these are control measures, powers given to the settler or the operator to actually be in control of how this trust fund is managed. Again, this may not be too good because, like I said earlier, the 3% contributed by the settler is not the only revenue or fund available in the trust fund. So if you're asking the settler to incorporate the HCDT to determine the members of his board of trustees, albeit in consultation with the community, and you're giving them all of these other powers to determine how many meetings they can have, to determine to stop funding the reserve fund, you are inadvertently giving them control over the trust fund. So as General Counsel, I would want to imagine that the GC incorporating the trust fund is working for the settler, right? So, I mean, why would I want to limit the powers of the settler I work for over the trust fund, if that makes sense? I would want, of course, my employer or clients to have control over the trust fund because they are the ones registering the trust fund and I work for them. So I think the question would be, the more appropriate question would be, how can counsel or advisors to the community, the host communities, make sure that the HCDT is insulated from the control of the settler? Actually, looking at the PIA, there is really not much that they can do, if we're being honest. because like I said, there is a list of different ways that the settlers can control that. So that now may bring us back to the regulator or to the parliament, to say, let us look for ways. I understand there's an amendment bill in the pipeline somewhere. We could try to incorporate this and make this a point to consider. How do we separate the settlers' influence, or how do we insulate the host community's development trust from the influence of the settler? Because in the PIA as it is, that is very difficult to achieve. So I'm thinking that if it is something that can be incorporated into the amendments to ensure that there are at least certain diversities. Some have argued actually that if you could make the powers or the functions of the HCDT Board of Trustees more functional, so you can separate their functional roles from the oversight that the settler has over them. But again, the PIA lists the number of things that should be in the Constitution. So most of all of those things are already taken care of and provided for. So I'm thinking that we could go back to the Parliament to say, please help us to separate these two and reduce the influence that the settler has over the HCDT. Thank you.
Thank you. That means this is an issue that is not going away soon. From what I hear, because the host communities are always going to want to exercise some level of control. The settler will also want to exercise, like you have said, control. Now, it brings me to a different conversation. We've had several divestments, mergers and acquisitions, sales, and all that in the sector lately. Now, this obligation ought to run with the asset, right? Now, so my question to you, Mr. Humphrey, will be the rights versus the limitations. What specific due diligence items should General Counsel insist on in midstream mergers and acquisition transactions? And how should successor liabilities for outstanding trust contributions be structured in these sale and purchase agreements?
Okay, thank you for that. Even before I would deal with it, and also because of time as well, there is one issue I wanted to talk about because it came up strongly yesterday. Yeah. I think that came from Frank. And I think it was a question that was posed to the panel yesterday, but they were not really the panel for the HCDT, but it came up, where the particular reference to him, he was asking that the multiplicity of host community type, there is NCD regulation on host community, as well as the same that you see in the HCDT under the authority regulations. And if the communities are not being shortchanged in terms of the fact that there are multiplicity, and which could also lead to some level of erosion. Yeah. But there's also a missing link as well, which by appeal to the authority would be to also have a look at this as well, so that because the gains or the objective or the philosophy around having HCDT harmonized under a regulation, first under the PIA, giving life to it, and then the regulations to then give effect to the implementation, is to sort of bring some level of governance around host community, which is a critical stakeholder for any the oil and gas value chain. But but the focus has always been on the licensee. So essentially, the oversight has been placed on licensee. So in the case of the operator, and you're looking at when the project has gone live. But in that ecosystem as well, there are also critical stakeholders who have critical role to play prior to for a project going live. So for example, using my vision as an example, OilServe, for example, OilServe has been involved in about 80-90% of the gas infrastructure in Nigeria in the past 30 years. They're involved in the AKK, the OB3, and the like. Now, as an APC contractor, you're not a licensee, right? So, but at project inception, you are building a pipeline, for example. You are interfacing with a lot of communities. Now, that ecosystem is not within the framework of the HCDT, but that has a critical impact on project delivery, project cost, because of the interfaces they're going to engage. For example, on the AKK section that we're working with, is a 300-kilometer stretch, cutting across Kogi State, Abuja, Niger State, over 100 communities. But at that space is essentially because the HCT kicks in when there's a project. When this project has gone live, then there's obligation to set up the HCT and the governance around it. But prior to that, there's also the NCD, there's also this host committee push and shove, which HCT is trying to solve. What has been in that space has been what we call some kind of FTO setup, which it is an uncharted territory. There's no governance. So what we try to say is that since we're not involved in this kind of conversations, a missing piece in the ecosystem is the service delivery angle that should come within the ambit of regulation oversight, so that governance is across board. And then that sets up. So I believe if we are to talk about improvement to the regulation, I think that's an area some attention should be paid to. And these are what I feel should be some kind of takeaway from the session as a way of how do we bring governance and sort of structure to ensure that what is perceived to be the key objective of having a host community development trust is also enshrined, and because the precursor is the GMOU, but that is what, because of the uncharted around the GMOE setup, that's why I have this. But in this other service delivery side, you have FTOs all over the place, no clarity. It only depends on to what extent of hand twisting it can push. So if we bring a regulatory oversight as well and some level of governance, then it presents some kind of structure and organization to also enable projects to be delivered within cost and on time. And then the true gains that we expect from this sort of structure is also cascaded down. So that would be my take to the authority as an area of engagement.
Thank you. Thank you very much for that. That was very insightful, because now we know where the pain points, where it pinches. And that's why, oil serve is very important on this panel. I've always thought about the AKK pipeline that cuts across states. And in determining what host communities you will deal with, if we go strictly by the definition of host communities in the Act, then you have host communities, so many of them. And then we have to determine how are you going to contribute your 3% to all these communities you cut across? So yeah, this is a very good point, but I'm not going to dwell on that. I'm just going to go now to another issue, a very critical issue, which is an issue of dispute resolution. Dr. Lamode touched on it briefly in his presentation, but now I want to bring it as a topic. Dispute resolution is important. In fact, whenever you're making any law, it's very important that you have a dispute resolution clause. When drafting all these contracts, it's important to have dispute resolution clause. And not just any dispute resolution clause, a commercially viable dispute resolution mechanism. We see situations where projects you have injunctions in court that pretty much freeze the projects. So now what we're asking here is, Dr. Lamode, this question is for you. Which courts should the NMDPRA consider requiring alternative dispute resolution clauses in the host community development trust constitutions as a condition of regulatory approval? And if you consider this important, what are the limits of the NMDPRA's own adjudicatory authority over trust disputes? Because from what Mr. Humphrey has said now, and from how we have seen the stretch of how these host communities will be determined, we're looking at disputes that, because how do you tell me my community does not qualify and this other community qualifies? Meanwhile, I can see the pipeline that runs right through my community. So, sir, please guide us here. should there be a dispute resolution clause that will be included in these host community development constitutions to ensure that some of these disputes do not impact the core operations that are being carried out by operators?
Thank you very much. I'm not a lawyer by profession, so I rely on the provisions of the PIA and the regulations to answer this question. Okay. But before then, I just want to make a simple point. We in the authority, we shy away from using settlers, because if you look at the PIA, settlers are defined as holders of PPL and PML. So the issue of and in the authority we don't issue PPL and PML. We only issue licenses. So we rather than talking about calling settlers, we rely on we say license operators. So going by your question, should the authority consider requiring an ADR clauses in the HCDT constitution? And I say, this will not require any new primary registration. And as I mentioned, if you look at the MP HCDT, clearly, there are requirements, submission of a proposed trust constitution for pre-approvals. And also, the authorities also empowers to issue guidelines, frameworks, rules, maybe templates for effective implementation of this HCDT. So since even within the regulation, if you look at Regulation 40, it already establishes the notice, then mediation, then arbitration in this sequence as the regulatory default for all HCDT, all disputes within the HCDT. Requiring a standard ADR clause in every constitution will simply, contractualize what this Regulation 40 already imposes. So the limit of our NMDPRA's adjudicatory authority is basically, if you look at the real limit, as I mentioned, is Regulation 40. We can draw our powers explicitly from it. And subsection 7 of that Regulation 40, the authority's role is basically a mediatory role. We are just to mediate when there's a dispute between whether it's the community and the operators or license holders. So the midstream and downstream, we also have the midstream and downstream petroleum Alternative Dispute Resolution Center that appoints a mediator. So the authority does not adjudicate rights. Any settlement reached is final and binding under Regulation 40, subsection 9 by force of the parties' agreement, not by force of regulatory order, which is a meaningful different legal basis from a court of judgment.
Thank you very much. Okay. Sorry, round up.
So I just want to make this point, most point, if you look at, I'm just drilling down on that Regulation 40, subsection 11, final resolution of any dispute by the authority shall not increase the budget of the trust unless the dispute relates to inaccurate calculation of the budget. That is the regulation which expressively, fends off the authority from using dispute resolution to the legislative contribution level. Thank you.
Thank you very much, Doctor, and thank you for pointing us to the ADR mechanisms provided by the authority. Our time is up, and in fact, I was skeptical in the beginning that what will my panel say for an hour? We were having a conversation about an hour is so long to talk, but then we've not even exhausted our questions. But then it's time to throw the questions to the House. Over the 2-day period, there have been questions about host communities, so we would like to, oh wow, this is encouraging. I see hands springing up quickly. So please, when you ask your question, you please identify the member of the panel you want to address your question. Or anybody can take it if you don't have any specific choice. Thank you.
Good afternoon, everybody. Franklin Ofua. I work for a law firm called Legal Works Associates, and I'm here at the behest of PNG Gas. I have done exhaustive work on host communities, and so I would beg to differ with a few of the comments that has come from the panel, especially the lady in green, with specific response to the issue of control by, I don't like the word settlor to allied companies over HCDTs. You know, the way this works is that the HCDTs are controlled by two separate laws. The Corporate Affairs Commission has a big hand in this, aside the authority. If you go to the extant provisions of the PIA, it says before the companies appoint the board of trustees, there must be a community engagement forum from where the trustees are nominated. The company is only a rubber stamp. Without those nominations coming from the Okpa locals and the AZs, all you're doing is an absolute waste of time. The governance structure is so strong that the company has no hold on any of those things. There's a management committee that is broken into two arms, the executive and the non-executive. And those are controlled by the communities. Then there's an omnibus body called the advisory committee that is a nominee of the host communities that form that trust. The only way companies can control trust is through the nomination or the appointment of the secretary of the board of trustees, which is their sole prerogative, and the management of the fund matrix. There are separate accounts that will be opened on the fund matrix, and some of those accounts has the companies as signatories to those accounts. Finally, just to round up, the companies, I disagree again, do not have an overarching control over host communities. It's actually the committees themselves that control the board of trustees. Thank you very much.
Thank you very much, sir. That's shed light to a pressing issue, and that's very helpful because the communities actually would rather have more control over how these funds are administered. So can we get the next question? Well, there are several questions. Compare, how much time do we have? Okay. So can we have questions, like, let's keep it short so that we could attend to all other questionnaires.
Yeah, so my own is also some form of clarification. My name is Innocent.
Okay.
So also the panel members made mention of the funding of the HCDT and said that the law also provides, except for the 3% OPEX, the law also mandates contributions, gifts, and the rest. My clarification is to the extent that the only part of those funding that is regulated is the 3% OPEX. Every other thing the law provides is not mandated, because gifts, honorarium, and the rest of it, you can't mandate anybody to give you that. It's only the settlor that are mandated to pay the 3% OPEX, and if you don't pay it, there are penalties attached to it. Yeah. So looking at the way the HCDT is structured currently in Nigeria, the only funding available is 3% OPEX. That's what I should provide that clarity. Thank you.
Thank you very much. Thank you. But the point was actually clear. Contributions are voluntary. It's ex gracias. Okay, so we have some questions this side, please. Can we? Okay.
Good afternoon. My name is Tochi Ejipa.
Please, after her, let's hear the lady towards the wall. Okay, we've been here. Let's hear from this side and we'll come back here. All right, please go.
Good afternoon. My name is Tochi Ejipa and I work with the Nigerian Investment Promotion. and we in charge of one of the members of the Nigerian International Nigerian Committee on the Negotiation of Bilateral Investment Treaties. So the issues of host community issues usually come up during our negotiations, and these under the African AFCFTA, this issue on protocol on investment in particular, issues of host community issues have come up, and it's very, very educative to hear that the PIA and the regulations have provided for host community issues, because these are one of the issues that come up during negotiations. And when you state that during negotiation, when you state that there is need for a balance of rights and obligations of host states, it becomes a problem with your negotiation partner. So I'm very happy that host community issues have come up. So my question here is, how can we create a balance? Because it came up during the session. Question is, how can we create a balance between the rights of these host communities and the obligations of the settlers or the company? Thank you.
Good afternoon, everyone. My name is Mariam Adebayo. I'm a lawyer. I work with 10 Plus. So I have a question regarding the applicability of host community, HTC generally. So if you look at the provision of the PIA, right, in terms of the people that are eligible to incorporate a trust, you will see what the PIA says is that the operator or owner of a designated facilities. If you look at the definition of designated facilities, you see things around refinery, depot, gas processing plants. They are specified in terms of what connotes designated facilities. But if you look at the provision of the regulation, when you look at the application sections, it says people that has this obligation to incorporate are license holder, right? So it sort of enlarged the scope of application beyond what the PIA provides. If I'm going by a literal interpretation, like what Dr. Tolorishe told us yesterday, it means if I owned a vessel coastal license as a midstream player, I have an host community obligation, part the provision of the regulations. But that is not what the PIA intended for that provision to operate as.
So sorry, the question, please.
That's the question.
It's because of the time. I know
okay, so my question is, there is a need to reconcile that provision of the PIA and the regulation. Is the authority looking at issuing a guideline, a policy to clarify? Because from where we sit as legal advisors, and when you do due diligence, when you do transaction M&As in this sector, these are naughty issues that the lender or the buyer or the sellers, as the case may be, are confronted with. So there's a need to address that misalignment. Thank you very much.
Thank you for the question.
That's a very good question.
Okay.
In fact, it ties to the first question I asked.
Sorry, can we just take all the
Dr.
questions? And please, I know we've almost spent 10 minutes just asking questions. So we'll just take 2 more, and then it will be addressed in like 5 minutes, because we still have the Q&A wrap up. So in case your question is not answered in this panel, there's still the Q&A. Okay. Okay, I defer to the authority. All right, please, let's have the questions. But let's keep it as brief as possible.
Good afternoon, everyone. Tolu Fadipe, Sahara Energy. I just wanted to mention in response to, sorry, what's the name, sir? Franklin. My own view, I sit as the secretary to the OMLA 148 HCDT, and it's been tough, right? First-hand experience, I can tell you that my conclusion is that the PIA and the whole HCDT structure is still the way we describe it, is still a work in progress. We all believe we are learning. As much as the PIA doesn't give room for, as much as the PIA gives a lot of discretion to the MANCOM advisory committee, BOT, and all that. In fact, you hear the BOT
So
members.
sorry, please, could you just land on the question? Because it seems like it's a response, and let's know who you're directing it to.
It's not, it's.
So we need to just stick to questions, if you don't mind. Just questions, please, please. During the Q&A wrap-up, we can do the feedback mechanism when we're doing the Q&A wrap-up with NMDPRA, but just questions.
Okay, good afternoon, everyone. My name is Oluwaseyi Ibeon. I work with Ocean Marine Solutions Limited. My question borders on his response on documenting incidents regarding sabotage. So I just wanted to clarify, is there like a one-stop shop or collaboration between NMDPRA and NOSDRA, considering the fact that when it comes to oil spill, they determine the cause of the sabotage? So is there something like that for NMDPR in respect of that?
Thank you for the question. Please, can we have 5 minutes on the timer?
Thank you very much for the questions.
I don't know if we can still take that. I see. Is that a question or is it a response? Please, very briefly. Very, very briefly.
Good afternoon, everybody. My name is Damilola Oripoyaku, GCL Energies. I'm not a lawyer, and so I'll certainly keep it short. My question is directed to NMDPRA. If a solution provider or a service provider wants to provide services or products to the host communities, how would such a provider, a consultant or solution provider, reach the different host communities?
Thank you for that. All right. Okay, just that one more, and that's it. Sorry.
Good afternoon, everyone. My name is Bobby Bublem from PNG Gas Limited. My question is regarding the 3% annual expenditure that was copied from upstream and now transferred to midstream companies. For a gas stripping company, a gas processing company, is the cost of gas included in this 3%? Because if the cost of gas is included, then the business may not be sustainable. So I'm pleading for the authority to review the 3% so that it will be sustainable for businesses to operate.
So it's a question and a plea.
Yeah.
Okay. All right. Thank you. We can't take any more. So as I said, there's a Q&A wrap-up with NMDPRA right after this panel, and then we have lunch. So I'm also very mindful because it's almost 3:30 p.m. Over to you, Mr. Moderator.
Thank you very much, and very encouraged by the responses. We expected this because we are all host communities, if you look at it very well. Everybody, it's a pain point that touches you one way or the other. So we're going to take the questions one after the other. There are more questions for Dr. Lamode, but there is one that Humphrey, I want you to answer. There's one I directed to you to please just respond to that, then I will direct the ones to Dr. Lamode.
That's a question with for the lady over there about balance, right?
Yes.
About balance between the host community and the the settler, the company. How I want to address this is that the whole it is not talking about balance, it's not a confrontational objective. They're not anti to each other. Rather, I think the balance is anchored on the principle or the philosophy that is underlying the setup, is to create that harmonious relationship whereby both are partners, co-partners on those facilities within the locality. So from that angle, it is about a relationship. So that balance exists. So as long as you see it from there, but I saw from some of the comments that was also coming around, it looks as if, with the issue of control, for example, now it looks as if control is more about driving an agenda. But I would say that if we still stick to the philosophy that drives this, then control issues or not shouldn't be, but rather it's about having great company and the community.
Thank you very much. And I like that point because if we look at where we're coming from with regards to host communities, vandalism, and militant struggle, you see why this Host Community Development Fund initiative being a law is important. Previously, it was like a corporate social responsibility. You either do scholarship for us or you build borehole for us. But now it's an obligation which is punishable if you fail to obey.
Which is why the whole ecosystem was put in that governance framework,
yes,
so that the gains cascade across board.
Awesome. So, Dr. Lamode, you have questions that require your inputs. I will start first with the question by a lady who says that there is a lacuna in the law, which is like there's some ambiguities with regards to the applicability of these HCDT provisions, whether it applies to upstream and whether it applies to midstream. This is you rehashing my first question. How do we as lawyers now, you said you're not a lawyer, but you have a very firm grasp of the regulation, the PIA. How do we tie it? If we're advising the midstream client, where do we point this client to say, look, this Host Community Development Trust initiative is your obligation and not just an upstream obligation? I talked about the definition of settlor, but now you can see also all the other designated facilities, and all those definitions tend to litter obligations all around the place. So can you tie it in for us, that particular question? Thank you.
Thank you so much, Mr. Moderator. I think I've noted quite a number of questions that are, directed to NMDPRA, and I would say directed to me. So I'll take them one by one, and I'll start by, what you just said. And I think during the course of the panel discussion, I mentioned that in the NMDPRA, we kind of shy away from using settlor. Basically, the fact that settlors, as defined the PIA, just made reference to holders of PPL and PIA. License holders, as it is, as in the midstream, is not mentioned under the Settlers Act. But this is a very important observation, because in administering any regulation, legal certainty and predictability is essential for both investors and host community. So the PIA, obligation on designated facility, whereas if you look at our regulations, we refer to facilities as license holders. These terms are not read together. They may appear to, if they are read together, they appear to be a broader obligation than the parent, which is the PIA intended. But if you look at it from a regulatory perspective, the principle is straightforward. The regulation should not give effect to the PIA. Normally, the regulation gives effect to the PIA, not expanding it. So the preferred interpretation is that reference to license holders should be understood as license or permit holders in respect to designated facilities covered by the PIA Act. So in my view, this is actually a drafting issue rather than a policy issue. The policy intent of the PIA is clear: to ensure the sustainable development of host communities while providing regulatory certainty for investors. So our task as regulators to ensure the implementation of this acts or intent of the PIA faithfully, So this is a matter that we are going to look at. The next question I noted that is actually related to NMDPRA is the issue of alignment with NOSDRA.
Yes.
Yeah, so NMDPRA and NOSDRA have two distinct statutory mandates. Both those mandates are, even though those mandates are complementary, making collaboration and for the benefit of the nation is necessary. So when we collaborate with NOSDRA. So if you look at under the PIA, NMDPRA is responsible for regulating both technical, commercial activities in a sustainable, environmental friendly, safe and efficient way within the, both for operation and infrastructural development within the midstream activity. While on the other hand, NOSDRA has the statutory mandate to detect, respond, and coordinate the management of spill and spill incidents, and to ensure, remediation of these incidents according to the law. So there are areas where this responsibility naturally intersect, and we normally, basically when it comes to environmental responses and emergency preparation, data sharing, joint inspection, so there is a need for collaboration, which is ongoing between NOSDRA and the NMDPRA, the service, the authority. The third question, which I also want to talk about, if there's a question about a service provider who wants to provide service to community, so how will he now be able to reach to this community? So if you look at under the HCDT framework, a service provider should not approach individual communities independently to offer service. Instead, the engagement should be through the governance structures that is established under the trust. So a typical pathway is for the service provider to identify any host community development trust, engage the trust management or the board of trustees in accordance with the procurement process, and governance procedures of the trust. Then they can now propose the services they want to render to this particular trust. And if approved, and I'm very sure you'll be able to render such services. So these are the three key questions that I noted that are directed to the authority. Thank you.
Doctor, there's one more, and the gas man said something about 3%.
Yes.
Does it?
Yes.
Does cost of gas included in the calculation of the 3%?
Yeah. So this is So this is a very also good question, and I think we've been approached and had several engagement and discussion when it comes to the legitimate concern that has been raised by a number of operators, particularly those models that involves purchase and processing of large volume of natural gas. The key issue is what is the actual meaning of the actual operating expenditure under the PIA. The Act requires that the 3% host community development trust contribution to be calculated on the actual operating of the preceding financial year. Whether the cost of purchasing gas should form part of that operating expenditure depends on the proper interpretation of the Act. So the applicable regulation, which is basically an accounting principle, and the commercial nature of the operation actually comes to play when it comes to that. So if you are looking at it from operators' perspective, the argument is that the cost of gas is essentially they are using gas as a feedstock, or which pass through cost rather than the expenditure that is incurred in the operation of the facility. And including it, could significantly increase their contribution towards the trust. So on the other hand, if you look at it from the perspective of either the community or the authority, the calculation must have a sound legal and regulatory basis. So as a regulator, we cannot simply exclude a cost item because it is commercially significant. The exclusion must be supported by law and applied consistently across the industry. So this is a conversation that is very ongoing. We'll look at it and continue to discuss, with the operators and see how implementing this will be business friendly to the operators that are concerned. Thank you.
Thank you very much, Doctor. And I hope the man who made the passionate plea can hold on to this. The conversation is ongoing, and hopefully it will be addressed. So our time is fast spent. We're going to wrap up very briefly. So I'm going to give you, let me say, 30 seconds to a minute, if the MC will permit, to just, final thoughts. I'll start with you, Chinemerem. Final thoughts.
Thank you, Mr. Moderator. So as a final thought, I wanted to add something to what Dr. Lamode said. To the lady that asked the question about designated facilities, I think I heard you mention water vessels, right? Yes, so those are not designated facilities based on the definition in the PIA. So I don't think it would apply, right? And if you also look at section 40, no, not section 40 now, either section 3 or what also of the regulation, it details who host communities are and what would qualify a community as a host community. So I wanted to just mention that, first of all, a water vessel is not a designated facility, and also the host communities are well listed in the regulations. Thank you.
Thank you very much. Okay, Mr. Humphrey.
Okay, for me, what I can say is if you look from the questions and interactions, one of the most engaged has been this section on the host community issues. So that tells you that this is quite high on the top burner. So it's also a call to action to the authority as well to also appreciate the level of awareness, yes, and as to also build on that momentum, because the host community is also a key stakeholder, is a partner of success for the operations in this locality. So they continue to do work to ensure that balance is there and that both see themselves as partners, but not as two collapsing their forces. Thank you.
Thank you very much. I'm very grateful to the panelists, Dr. Lamode, Mr. Humphrey, and Chinemerem. I'm very grateful for your time.
No, the final thought from me.
Dr. Lamode, I'm so sorry. I was thinking because you have had several thoughts. But okay, let's get your final thoughts and then we wrap it up. Thank you.
And I think it's good that I mentioned this. This is an opportunity. So one key thought for me, is the success of this host community development trust will not be measured by the amount of money we contribute, but the level of trust, we build among communities, operators, and the government, so that, operators and communities, that harmonious, that relationship is very, very, very cordial. So the PIA has provided that opportunity. For us as regulators, our commitment is to implement the law fairly, providing what everyone is hearing for that regulatory certainty and creating that enabling environment for investors. And we are also urging our operators, to comply, so that compliance is not seen as just merely a legal obligation, but an investment in operational stability for long-term business sustainability, not just for the nation, but adding value for our people and Nigeria as a whole. Thank you.
Thank you very much, Doctor, and thank you very much, panelists. We're very grateful. Thank you to the crowd for making this a very engaging session. In fact, from all the sessions I attended, this is the one that garnered the most questions, and that is very comforting because this is a very telling issue. We're going to continue talking about it until we get it right. So thank you all for your time, and I appreciate you.
Thank you so much to our able moderator and panelists. Please rise for the group picture. And yes, we'll still have a chance to ask some of your questions. I'll now like to invite Mrs. Ngozi Nwankwo, the Regional Coordinator, Southeast NMDPRA, to present our token of appreciation. Please give her a round of applause as she makes her way to the stage. And right after that, we're going to have the Q&A. So I know we're hungry, but please, this is very important that you get all the answers directly from the NMDPRA. So please, let's keep our questions brief so we can take as many as possible. We can do the feedback mechanism during lunch. We can always write to them, but let's keep it about the questions. It's truly, truly appreciated. Thank you very much. Big smiles, please. This is our final panel, and we'll now have the interactive wrap-up. I'd like to invite the coordinator, Midstream and Downstream Petroleum Alternative Disputes Resolution Center, NMDPRA. Please put your hands together for Dr. Charles Nwachuku. I'm sure if you clap louder, you probably get more time to ask more questions. So I think you will do better with the applause.